Welcome to This Explainer. Today, we're diving deep into the hidden legal realities of buying real estate in British Columbia. We're going to strip away all that confusing jargon and use the exact legal codes, practice materials, and acts that govern the province to uncover how the system actually works. If you're navigating this high-stakes market, you really cannot afford to be in the dark.
So let's jump right into the core illusion here. Think signing a contract and handing over the money makes you the legal owner of a property in BC? Well, think again. A lot of buyers, especially in high-value markets like North Vancouver, just assume that a signed contract and a cleared check guarantee ownership. But honestly, making that assumption leaves you incredibly vulnerable.
Here's where the big disconnect happens. The common perception is that, the deal is basically done at the signing table, but the legal reality? It's quite different. Under British Columbia law, specifically the Property Law Act, ownership literally does not officially transfer until your title is successfully registered at the Land Title Office.
To understand why it works this way, we have to look at BC's pretty unique framework, which is called the Torrens system. Now, the absolute magic word here is indefeasibility. What does that mean in plain English? Basically, a state of title certificate is conclusive evidence of your ownership. You don't have to go digging through paper trails to trace a deed back hundreds of years to prove the land is yours. The registry itself is the ultimate proof. And that makes proper, flawless registration absolutely the most critical step of your entire purchase. Because that registration is so paramount, a lot of people totally misunderstand the role of their legal representation. Many buyers in places like North Vancouver think a real estate lawyer is just there to, flip through pages and witness a few signatures on closing day. But the legal reality is much deeper. The source materials we're looking at make it crystal clear. The buyer's lawyer does the real heavy lifting. BC courts have actually made it explicitly clear. Your lawyer is not a mere document typist. They are basically your lead investigator. They have a strict legal duty to actively investigate your residency status, verify your corporate or tax structuring, and execute crucial filings like the Landowner Transparency Registry. They also have to ensure you're in total compliance with federal bans on foreign buyers. And trust me, you want them doing this, because a single violation there could slap you with a $10,000 fine and even a court-ordered forced resale of the property. Yikes.
Section 1. Navigating the tax maze. Let's talk about the hidden costs in BC. From calculating complex property transfer taxes and tracking foreign buyer penalties to reviewing hidden municipal restrictions on a title, a single oversight can literally cost you hundreds of thousands of dollars. Your lawyer has to meticulously calculate these tax brackets. You see, it isn't just a flat fee. It's 1% on the first $200,000, 2% up to $2 million, and 3% over $2 million. And if you are buying a residential property over $3 million, boom, you're hit with an extra 2% tax, which brings that top bracket to a staggering 5%.
But wait, brace yourself, because it can get even more expensive, 20%. If you happen to be a foreign entity or a taxable trustee buying in specified areas like Metro Vancouver, your lawyer must calculate an additional massive 20% tax. That is right on top of the standard brackets we just talked about. It is a really painful hit to the closing budget, and navigating the very few exemptions to this requires some deep, highly specialized legal knowledge. Section 2. Pre-sale traps and rescissions. Your lawyer is also there to protect you from hidden pre-sale contract traps. As an example, BC is actually the only province in Canada right now to implement a mandatory cooling-off period for used residential properties. This gives you a narrow little window to rescind a contract after it's signed by serving written notice. However, stepping away is definitely not free. To stop buyers from just making multiple bids all across the city and walking away risk-free, the law imposes a 0.25% penalty. So putting that into perspective, if you exercise this right on a $1 million property, you are legally mandated to pay the seller $2,500. It's a pretty significant financial risk that your lawyer absolutely must factor in before you ever even make that offer. Your legal advocate also makes sure you are in compliance with restrictive clauses like Section 20A. Now, previously, buyers could assign their contracts to third parties for a quick profit right before closing. But to put a stop to shadow flipping, regulations now mandate that you cannot assign a contract without the original seller's written consent. And crucially, the seller is entitled to any profit resulting from that assignment. Your lawyer makes sure you aren't caught off guard by these pretty rigid boundaries. Section 3. Securing your BC investment. Why legal advocacy really matters.
The scope of what your lawyer actually protects you from is vast. I'm talking everything from discovering escheated, unowned land that has quietly reverted back to the provincial crown to managing your massive deposits safely in a trust. What you're seeing here is the actual super dense legislative text from the Property Law Act. Real estate agents are fantastic at finding you the right home, for sure, but you need a legal expert who knows precisely how to interpret these exact statutes to legally secure your interests the minute the ink dries.
And that brings us to a really fundamental rule, straight from the real estate practice materials. Despite the many real estate agents, mortgage brokers, and assistants involved in a transaction, you must have one legal professional in charge whose sole ethical duty is to you. They are basically the final line of defense for your money and your future home. Which is exactly why you should never, ever rely on the seller's legal team to protect your investment. You need your own independent advocate. Protect your piece of British Columbia. Contact Pax Law Corporation today to secure your real estate closing. So, before you go ahead and hand over that massive deposit check for a property in BC, ask yourself, do you truly have the independent legal advocacy you need, or are you just sort of hoping your signature is enough? Thanks for joining me on this explainer today. Remember, when it comes to BC real estate, knowing the law is the absolute only way to truly own the land.